Hello and welcome to Legalbytes. If you are new here, my name, of course, is Alita. I'm a lawyer and I'm licensed in California and DC. And yes, Andy, it is indeed Halo time. I see that in the chat, and we are going to be playing Halo. No, I'm just kidding. We're not playing Halo. We're talking about the law. So
I want to play Halo.
I know we should, right? That would be fun. That would be a fun live stream.
Oh yeah, we can go back and play Among Us. That'd be cool. Watch all the lawyers backstab each other.
Lawyers being lawyers.
Yeah.
That would be great. So I have with me, of course, the wonderful, the affable, the intelligent, fantastic, uncivil law.
What? I'm doing reasonably well, all things considered. It's a tough life. I'm having a very busy month, but I'm doing this to try to make myself feel a little better, because I enjoy streaming, and then I'll after this go to work for probably the next 8 hours or something. So yeah.
Oh man, that's rough. That's rough.
Yeah.
But at least the streaming is fun.
Streaming is fun.
Yeah.
And the channel's growing very nicely. What are you at these days?
I am at 41,000, a little over 41,000.
Hey, Legal Mindset, how's it going?
How's it going? How are you?
41,000.
What's that?
I said I am under 41,000.
No,
if we're doing over under.
Yeah. You've been doing well too, though. Your channel has been expanding.
I'm loving it. No, and look, I love it, and it's been actually great to do the morning streams. I actually didn't think about that because it's sort of like I've always done PM streams. My morning streams, like right before Nick gets on, apparently there's a lot of these freaky Europeans, these weird people from places in Europe. Who's even heard of Europe? Like Lithuania? Like where's that? Like where's that country? Yeah,
I know.
Is that a made-up country?
It's right there. Like, that's where it is.
Is that like Narnia? So
I don't know. Some people sometimes think it's in Africa because it sounds like Tanzania, Lithuania.
That's weird.
Is that Liechtenstein?
You're so African, Alita. You're so African looking.
There's a Mean Girls quote in there. If you're from Africa, why are you white? Oh my God, Karen, you can't just ask someone why they're white. Anyhow, but I am currently in California.
California.
I know.
I made subs away from 46,000. I need 8 subs for 46,000.
Oh, there you go.
Somebody simp for Kurt.
Everybody go subscribe to Uncivil Law. He needs to get there.
I was hoping for 50 by the end of the year was my stretch goal. I don't think I'm going to quite make it, but I'll get close.
You know what my stretch goal was for the end of the year? 10,000.
Yeah.
Right
past that.
Mine was way low. Yeah, I was like, if I make like 5,000 and I get like 50 people in my live streams, and then today it's like when I am hitting over 1,000, I'm like, this is fucking awesome. This is great. And it's fun. I love doing it. And I love Kurt. We did an awesome one the other day on whole women's health, which I know we'll talk about today. Right.
Yeah.
But the formats we have, everybody does something slightly different. Like you are pretty unique in doing that format, but like, that's what's good is that like you can follow what you like. And
I like it. Damn it.
I like it too. Let me be clear, Kurt. I like it too.
Hey, Joe. How's it going?
Joe.
Hey.
What's going on, brother? You're too happy right now.
Is your car okay? I got a message from Joe right before we went live that he said that his car may have been stolen. Is everything okay?
I said, I think my car was stolen because I came out and I'm like, where the heck is my car? Now, so my wife has her car and there's my car and neither car is there.
Oh, no.
And I figured, okay, I guess my daughter took my daughter old enough to drive. So I was like, I guess she took my wife's car. I was like, where's my car? And I was like kind of internally freaking out. And I was having like a pre-game cigarette. And I was like, this is really disconcerting. I like looked down the block, like, did they move it somewhere? Like, and I'm like, nah, it's nowhere. It's nowhere. I was like, oh my God, I really think my car was stolen. And then I have Alita text me and saying we're backstage. And I'm like, I think my car was stolen. And I come inside and I ask my wife and she's like, no, Rika, my daughter took the car. And I'm like, oh, okay, where's your car? She's like, it's still not back from the oil change. And I was like, oh, phew. Okay. I feel way better. Yeah.
Oh my God. Oh, that's good. That's good.
So we're all
Okay,
good.
so good to know.
It
Car's
was
not
stolen. It was
stolen.
stolen by my daughter, basically.
Well, yeah, that's
But
true. That's
that's
fair.
acceptable. Yeah.
So yeah, so before we get into these super fun topics, if you guys are new to this channel and you're new to the Clips channel, and if you can't hang out for the whole thing, I have a new Legalbytes Clips channel that I have started. I've been working with an editor to kind of test it out. And so all of my live streams right now are being monitored by the editor, and we're posting clips onto that channel. So
hook me up with your editor. I could probably use the help too.
Sure.
I edit a lot of my stuff myself, and I could use some help.
Well, he's watching, so he'll probably send you a
Hello,
DM.
editor. Please contact me on Twitter or DM me in Discord and let me know what your availability looks like to cut down my stuff.
Yeah,
I've started doing clips too. It's really good to get, because a lot of times when we get these long form conversations, we're about to get in a conversation where we're going to talk about like 5 or 6 different topics.
Yep.
But sometimes you just want information on one of those discrete topics. You're just interested in one of those topics. So it's good to be able to tune in. Timestamps help, but clips are better. So I've started doing it. I think it's a good idea for everybody. So get with Kurt. Get with Kurt.
Yeah, so we're testing it out, and so far it's been doing pretty well. I just posted yesterday a clip from the Natalie Wisco interview when we rated different Kyle Rittenhouse memes, and he did a great job of like adding in graphics and music and all kinds of stuff. So we really were going back and forth on this sort of like what I wanted, and he kind of just ran with it. So it was really great. It was really nice sort of a test run on a lot of this kind of stuff. But most of it so far has been just like little bits and pieces of these conversations that we've been having. So if you can't sit around for a 2-hour, 3-hour, 4 or 5-hour live stream, understandable. The Clips channel is a good idea. So there's a link in the description below. Go ahead and subscribe there, watch some stuff. Because that'll really help me to sort of figure out if it's going to continue to work in the future.
I demand that you listen. I demand you listen to the full form of my stuff. You must listen to every single word and every pronouncement I give. It's all gold.
Well, the good thing about it too is that if somebody goes and watches a clip and then they get kind of hooked into it, then they're like, oh, I really should watch this whole live stream. Whereas otherwise they may have been like, oh, this is a little too long for me. So, anyhow. I also have everyone here linked in the description below. So if you are not, for some reason, if for whatever crazy reason, you're not already subscribed to these guys,
you're insane. You
need to be. You are. This is a you're ruining Christmas if you haven't already. So anyway, so yeah, everybody's linked in the description below. And with that, let's get started. We've got some interesting stuff as usual. Let's talk about Kim Potter, because I know
she's not guilty. She's not guilty. It's done. It's over. It's a wrap. Like,
yeah,
I saw was there with me. It's like
I saw your tweet earlier from the
not guilty
from the what was it, the taser training,
the trainer
expert?
Yes, who was her 15-year friend. This is a prosecution witness they decided with their time and money to spend to bring onto the stand, right? This is a police trainer who's known her for 15 years, said she's a good cop, pretty much, law-abiding, peaceful, right? And pretty much all of his answers for the cross were like, yep, absolutely, yes. For the prosecutors, for the guy who looks like my uncle, Frank's, right? Except for he's the uncle we don't invite to Thanksgiving because he's a douchebag. But that aside,
he's got the same Fed haircut.
it was always like, well, it depends, and there's a lot of factors, and this and that. He never gave him a straight answer. And Kirk, correct me if I'm wrong, but he gave him a no at one point as well. Like, he literally said no at one point to him, which is like, you hardly ever see that from your own witness.
Well, this is also kind of a difficult case for the prosecution in that respect, in that, they need to get these cops to testify against another cop, knowing full well that they could be in this defendant's position at some point in their own careers. So it's a very awkward place for these individuals to be on that alone. Number two, a lot of these people are in fact friends of hers. Like she was the union leader at one point, right? And she's been like volunteering in all kinds of different positions around the force. So it's like a lot of these guys, they know her and they're friends with her. So it's hard for them to, to come out and testify disfavorably against her in that kind of a case. So yeah. But that's super interesting. So I know yesterday there was a lot of policy that the prosecution was putting on, a lot of policy about tasers, a lot of policies about moving vehicles and pursuit and all that kind of stuff. But it just sounded like they were basically overwhelming the jury with a lot of junk, which seems to be a strategy when you don't really have many facts in your case, is you just kind of try to dump truck everything onto the jury. Like, we have facts, they're in here somewhere, you figure it out. But it's I don't know that that's going to be a winning strategy. Kurt, what do you think about it?
I felt long ago that the prosecution had no case. This has been dragging on for days and days, them asking questions that seem to go nowhere and have no purpose in developing a factual pattern. There's nothing here. And then, of course, with the taser persons, like, yeah, people make mistakes. That's why we train on it, no matter how hard we try. And every situation is a little bit different. And then I did like the question on cross about, let me give you a hypothetical. Suppose for a hypothetical, and then basically just lays out the facts of this case. and of course the other side objects, but it's an overrule. It's like, yeah, that seems like that would be a good time to use a taser. I think so, yeah. So yeah, and this strange hypothetical, which we'll ignore, is basically the real case. Yeah.
That was real great yesterday. That was great. And seeing the on recross. The state trying to rehabilitate the witness after that was just like they were just floundering. They were floundering. It was very interesting to see. I'll put it that way. So but just for clarity, for I know that a lot of people are sort of struggling. You know, I've had conversations in real time with people about this case, and a lot of people are struggling with the fact that that this is a very real case where you have a police officer that drew a taser when drew a firearm when she intended to draw a taser. And there's this question that a lot of people have of like, how can that not be recklessness? Like, it just seems like that's such a huge mistake to make that it can't be, that she would have to be convicted, you know, in some way.
Well, he kind of, they may not know it, but they kind of answered their own question when they asked the question that way. It's like, why is this not recklessness? It's such a huge mistake to make. It's like, you answered your own question. Recklessness is not mistake. Recklessness is conscious disregard of a situation where there's a substantial risk to people, but you know the risk exists, or you should be conscious of a risk. You may not know the exact risk. So that's the difference, like, between knowing and recklessness. So you may not know the exact risk, but you know that there's a risk that you're generating, and you're conscious about that, and you're ignoring all that. So mistake is not that. Accident is not that. So, you know, you answered your own question. So give me another one.
Yeah.
And I think they're confusing the civil standard and the criminal standard, right? Because I mean, the civil standard is not the criminal standard. I mean, most normal people don't understand much at all, you know. So they're saying, "Oh, well, this seems like it's a negligence case, like a slip and fall standard for criminal law," and that's just not what applies here. Now, this wouldn't preclude a civil suit, you know, by the estate, right? There's nothing that precludes that, and we can argue about that. I think that's a more interesting fact pattern, right? Like, is there civil liability here, right? That's more,
which I think there is in spades. I think there definitely is, for sure, a negligence claim here. And in fact, you know, in these kinds of cases, it's very common for there to be a civil case that follows the criminal case, because and one reason why it might actually follow the criminal case is that if there is a conviction, then you really don't have much to litigate over, because that's a higher burden to be convicted of the crime than the burden is to be found liable civilly. So if she is convicted of manslaughter in this case, there's for sure negligence. So that would be a very quick settlement and a very heavy settlement in favor of the decedent, in this case, Dante Wright. Now, that said, there could still be a very hefty civil settlement in this case anyway, which would be really interesting. But Joe,
let's call a spade a spade. Okay, if Dante Wright was Brad Wright, he was a white guy, there would have been no criminal prosecution. That's just reality. of the times that we're living in here. I hope that's not an objectionable thing to say. That's just looking at reality. That if he was and that's because this isn't a crime, and this whole prosecution is really a reaction to the times that we're living in. So it's not surprising that this prosecution. I'm not saying this in an angry sort of way. I'm just looking at it objectively as to what is a crime versus what is civil liability, and that's probably the way justice is probably best handled, along the lines that all three of you were properly stating, that this does not qualify as a crime because it's not genuine recklessness, but there was actual damages and there was negligence. And the reason why that makes sense from a judicial philosophical perspective is that we put people in prison because we say you're intentionally doing something wrong, and we want to punish you for that intent that you did something wrong. And even if that intent to do something wrong is you're intentionally being reckless, that's a reason to put someone in jail, so that we're protecting society from someone who will intentionally go out tomorrow or next month or next year and do something intentionally reckless, or beyond reckless, intentionally trying to harm others. So we're trying to protect society from this person who is basically a walking hazard zone, and in one way or another. And that's the purpose, or to rehabilitate them, right? So if you want to look at it as a rehabilitation thing, we want, look, you have some sort of issue that is harmful to society, and we want to rehabilitate you so you're not going to do that again. Neither of those bases to put someone in prison applies in the Kim Potter case, because she had no idea that she was doing something wrong at the moment that she was doing something wrong. And that's why, from a criminal perspective, it made little sense. And that's why this entire trial, I'm saying, is on the basis of race, and it's more political than anything else. It's a matter of assuaging the heated passions of white cop kills black victim. And that's really what this is about at the end of the day. That doesn't mean that justice demands that or the society is benefited by putting Kim in jail. Now, at the same time, with respect to civil liability, well, Daunte Wright is dead, and it was her negligence that caused that death, which means that Potter and the police force are now open to civil liability for causing that damage through negligence. And negligence is best handled in the civil courts, where someone with his damages and his loss, let's say he wasn't dead, but he himself was living, it was still alive, but very, very injured. You would say, you know what, it's affected his life. He has a right to get compensated for that. And that's irrespective of skin color or anything of that matter. It's just your negligence, and the negligence of the police department's employee led to this bad result, which is clearly a terrible result that no one's happy about. And the best way to rectify that is through monetary compensation. And that's why we have our civil courts for that, to handle this sort of negligence that was committed by Kim Potter.
Yeah. I mean, and that's a very fair point. I mean, putting Kim Potter in jail does not necessarily get the family of Daunte Wright anything back, but a civil case to a certain extent does, where, you know, although it's not the kind of situation, or it's not something that can ever replace a human being in your life, right? Like for his poor mother, you know, she although the cross-examination of her by Earl Grey was actually very masterful, he did a fantastic job. At the same time, she's still a grieving mother, and I still very much feel for her, of course. So, you know, for someone like her, she has lost one of her sons through this whole case. And financial compensation is never going to bring him back, but it may help to sort of, I don't know, dim the sting a little bit to a certain extent. You know, like it's the only way that our civil justice system really knows how to compensate people for loss of life in these kinds of cases.
And arguably, with respect to the police department, if they're hit with this sort of civil damage, they change their training policies to make it less likely that something like this will happen again in the future. So again, that's another basis to say that civil penalties against both Kim and the state, which, let's face it, it'll be picked up by the government. They're the ones on the paying the tab. That's appropriate, and that's a way to sort of get government to make sure that they're taking steps so that this sort of negligence does not happen again. Because nobody in hell wants to see another situation like this unfold again in the future.
No, absolutely not. Absolutely not. But despite the fact of how we feel about it, and just to be clear, my stance has always been we can feel like a situation is morally horrible, right? It's ethically horrible. It makes us feel absolutely horrible, but we have to separate our feelings from the facts and the law. Right. And the facts and the law say this is not an appropriate punishment under the law. And I think Joe is absolutely right, and Alita is exactly right about civil and the civil liability here. And also, you got to understand that we can feel bad for him on one hand, but at the same time, civil liability has something called comparative negligence. We're going to take into account the fact that he was high, that he was resisting arrest, that he had a warrant out for his arrest, right? That he did not have to do what he did in that action, right? If he just said, "Okay, yeah, I'm going with the cops," he would still be alive today, right? So that's something you factor in a civil case, and you portion that out. Right? If it's not something that's settled. And by the way, I think they would settle this. Like as a person who's represented cities, they're settling this bad boy. They're not taking this to trial.
I think so for sure. And I do see comments in the chat about the mother that she had 20 years to raise him right, that she knowingly gave an uninsured car to a son with no driver's license. I completely agree. I agree. All of those are, there are ways that she could have potentially done a better job raising her son. I have a hard time judging someone else for that when I have not raised any children myself, other than tangentially through like nieces and nephews and whatnot.
You have pets.
But then I do have pets. I have a zoo, and I have basically a baseball team of nieces and nephews. I have a lot of them. And hey, Nate, welcome. Hey. But but at the same time, that doesn't.
You gotta say it right, man. You gotta say it right.
Juice, baby.
My God, country.
That's a good Nigerian name. You gotta play like you're like Forrest Whitaker, Last King of Scotland level there. That was good.
Nice.
Thank you, my brothers. Thank you.
Yeah, when Hollywood.
Country, brother.
When Hollywood makes a movie about us, it's definitely Forrest Whitaker who's going to be playing Nate. That's for sure.
So Virtual Loner here says, since they practice drawing their gun more often than the taser, it's more natural to do that without conscious thought. What do you guys think about that comment?
Since the practice,
I mean, it seems.
What does that have to do with the criminal case? Are we talking about civil right now? Or are we talking like? What are we talking about?
I think they were just kind of referring to the nature of the mistake, that it seems like it would be natural for someone to draw their gun in that kind of a scenario and not necessarily their taser, because they probably have more practice. Now, I don't know if they actually do have more practice in Brooklyn Center Police Department with drawing their firearms as opposed to the taser, or if she specifically did. But I do understand that officers probably do a lot of target practice with their guns, right?
Yeah, usually usually for like your firearms qualification, it's a week-long course. The original one is like 2 weeks, but then the research every year is a week course just for the firearm. Where I think tasers and pepper spray and even batons, those are like 2 or 3 days maybe. I used to do the training for the batons and the handcuffing, for instance, and they gave me like 3 days to do that training, and then you'd still go over the use of force principles. So it's not, you would be more familiar with pulling your gun if you're talking about just the training aspect. But most cops don't pull their firearm at all during their career. And that's actually a pretty rare occasion to actually pull your firearm. And your taser, you actually probably be pulling your taser a little bit more. But I before we move on, I want to make sure everybody understands the standard. They have to prove that she made a conscious disregard, right? So she made a conscious decision to pull the gun, and that danger was created. So when that gun went off, she created that danger. It was an unjustifiable risk. So they can't, if the defense shows that it was a mistake, then you don't have that conscious disregard, because that conscious disregard is I'm making a choice to create this danger. And without that, then you don't have that choice. You don't have that conscious disregard.
Right, exactly. So Andy the Game Maker says, hey, Andrew, are you in the world's tiniest sound studio? That thermostat looks like the world's smallest sound mixer. DJ Andrew.
Everything is smaller in Korea.
And then Z. Michael Gelka says, nothing ethically wrong happened here except by Mr. Wright. Miss Potter is suffering from a human fault caused by Mr. Wright's criminality, which that's definitely the position that the defense is taking here. They've been kind of hounding that point, right? Saying that if only he would have complied, if only he wouldn't have resisted arrest, if only he wouldn't have started to try to flee to get away from them, he would have been alive and there wouldn't have been any case here at all, because everything would have happened much more smoothly, much more safely. She would have never drawn her gun. And also, Nate, to your point earlier, that it from the testimony that has come out so far, I think in testimony, at the very least in the opening statement, they said that that Kim before this day had never drawn her gun and had never drawn her taser. So she is one of those examples of somebody that never had any experience actually using it on, while out on duty, out in the field.
Yeah, you're trained on it every year, and I think a lot of people just fail to realize that 99.9% of the actions with police aren't rough and tumble. But unfortunately, I think this officer who, like we're saying, has never pulled the taser, never pulled the gun. You're in a hot situation with somebody who's jumping in a car and trying to drive off with cops, all hanging over the car. It's people don't. If you're looking to ask when people make the most mistakes as officers, it's in those type of situations. Remember, the law gives you this leeway to make those split-second rash decisions and demands that juries can't go back and say, well, at hindsight, what should you have done, right? Because it's really what happened in that moment. And unfortunately, what this officer did was negligent, but I don't think it's criminal at all, because I just don't think you have that conscious disregard.
And Nate, that's exactly what the prosecution is asking us to do. They're asking us to go back and slow this down to like fractions of a millisecond, which once again, I have a problem with this analysis. Anytime we're getting down to like fractions of a second, it's your mind doesn't function like that. But they're saying, oh, well, should he factor in, for example, they're saying, oh, factor in that his foot was near the pedal or that he could have turned the car on and all these other things. They're trying to get them to focus on all of these factors. And it's like, yeah, but bro, this happened in like 0.5 of a second. Like everything happened like that. How are you supposed to factor those things in? Which is why you're exactly right, Nate, which is why you can't get conscious disregard.
Well, I don't want to make it too much of a broad brush because, for instance, in the Rittenhouse case, right? In the Rittenhouse case with Gage Grossford, they showed him a still picture of him pointing a gun at Kyle's head, right? And you guys were all like, "Oh my God, it's over! It's the thing, right?" That was a still photo, but I think that made the case, right? It absolutely showed Kyle was justified. And it was a still photo of something that happened in point something seconds. So I think it all depends on the context in which you're using it and how it's being presented to the jury, and not in a way that makes it seem something that's not. And I do agree with you in this particular case. They're trying to make that one moment into something it's not. They're deceptively trying to make it into something it's not. But I think you can. But I just want to make it very clear. You can use a still image of a situation to really illustrate a point. And I think they did that well in the Rittenhouse case.
That's fair. That's very fair.
Yeah.
Also, at the risk of contradicting the panel, I'm not 100% sold on the negligence either for the civil standard. I think there's room to fight that issue.
Well, Kurt, I'm not saying that they get past, because here's the thing: in most states, if you get to 50% plus one, in terms of negligence on the side of Dante Wright, then that precludes his claim, right?
Yes, so in every state, I believe.
Yeah. Well, I don't know. There might be some crazy states out there. Who knows, right?
Louisiana is always one of those.
As long as we're talking about crazy states, we can talk about Maryland, DC, and Virginia, which still have contributory liability. So if you're 1%, you don't get recovery.
That's insane.
Yeah, I agree. But hey, welcome to what it is. But
so there we go. Yeah, it's possible. It's possible a court could say that Dante Wright was more than 50%. So I think it's plausible. That's something we could argue, right?
For her, it's not obvious. For the department, maybe, because the taser they used was the same color and stuff like that. So maybe there's negligence there in that kind of thing, where it's similar grip. So maybe for the department, but I'm not 100% sold on the negligence for Potter.
Well,
I think that
she gets over 50. But
go ahead, Nate. Go ahead. Yeah.
No, I'm just saying. I think she gets over 50. You get over 50% with Potter for what happened afterwards. I mistake. I shot him with the wrong gun. Like, she's sitting and saying, "Oh my God, I grabbed the wrong thing. I made a whole mistake. Oh no, I did the wrong thing." That is going. That right there, I think you're at your negligence. but now it's trying to say, well, how much did Dante contribute to this negligence, like you're saying? So I think, her
I'll represent
saying,
Potter.
oh my
you
God,
can represent the Dante. We'll go at it, baby.
yeah, I mean, play the tape.
That's a good stream,
She said
baby.
she made a mistake.
Yeah. And I there, so the prosecution is making a big deal about where her taser is and the position that it's in, right? Either cross draw or what's the reaction draw, right? So reaction draw meaning that you can draw it with your left hand. That's considered the safer way to do it, which is how she had it and how she's had it for a long time. So the question is, how in that moment did she like reach over or like think she was going to reach over or something with her right hand and instead grabbed her gun in the moment? There's still a good question about whether she was using reasonable care in that situation, making a mistake. It's just a much lower standard than recklessness. I think that there's much more of a possibility of the plaintiff in that case meeting that burden.
I agree with you that it's easier. I am not saying that that's not tenable. I'm just not completely sold. One of the reasons I'm not completely sold is because I think there's a pretty credible case that she could have used the firearm itself. And so if she could have used the firearm,
That's
then
fair.
by using the firearm, even accidentally, she didn't breach her duty, right?
That's
so
fair.
if she's within the scope of using the firearm, so it wouldn't be a breach of duty for her to purposefully use the firearm, then her lack of care that led to her using the firearm is still not a breach of duty. So that's kind of where I'm thinking there might be a problem.
Which would be an interesting scenario, because there you would have her saying, "Oh my God, I screwed up," when technically she didn't. She was
I screwed up and made an accident.
Right, I made an accident that I thought I was using A when I was really using B, but under the rules of the policy guidelines or what's appropriate conduct for a police officer, she didn't. She's actually being harder on herself than the policy would be, because she misunderstands where she's allowed to use the gun, and she has more license to use the gun than she realized.
Yeah.
So she made a mistake because her intent was to use the taser, but
Right.
if she had I mean, I don't need to go through the analysis again. It just, I think there's a case to be made there.
I think that's a fair point.
But even without the analysis, it all depends on the defense. What is the defense going to be? Because there is no such thing as accidental self-defense, right? So if she's saying this was a kind of a self-defense issue, and they're raising that, she's defending herself and life of others, then you can't pull a gun out and shoot and say, "I did it by accident," right? You have to confidently say that I did.
Qualified immunity?
Go ahead.
For the civil? Well, there's
for
always
the civil,
that.
yes.
Yeah, there's always
We're talking
qualified
about
immunity,
for the criminal.
Oh,
yeah,
sorry.
That's true
Yeah,
too.
I think you got qualified immunity. But the thing is that still the city gets hit though, right? It's not like nobody gets paid. The city gets hit with the money. Now, that means you just can't go after the cop individually, but the city still indemnifies. So
yeah. No, that's all fair. So should we move on to our next topic?
Let's do it.
Let's actually switch things up a little bit. Let's talk about whole women's health. Because I know there's
you're going rogue.
Yeah, there was a Supreme Court opinion that was just handed down at the end of last week. There was a lot that happened last week, right? Jussie Smollett came out. The Josh Duggar conviction happened as well, and whole women's health. The Supreme Court came down with their opinion, which was kind of a mixed bag. It sounded like, right? Kurt, I think you covered this quite a bit.
Yeah, it was, let's discuss what whole women's health was trying to decide. So it was a procedural issue rather than a substantive issue. So the question is, can certain people be sued? And who can properly be sued? So the question wasn't really what is the law as it relates to abortion in a substantive way. It's like, can these people be sued at all? Right. So let's just clarify that.
Right.
So what they said, so Whole Women's Health, which is an abortion clinic, sued a whole bunch of people. They sued the attorney general. They sued like the various heads of health and human services, head of nursing, head of whatever, various government officials that are head of various medical departments, and one random guy for some reason,
a private citizen
who had made some or he had been an activist in this area. I think
he was mean to women.
He's also signed a declaration saying that was just all talk, and I'm not going to do that. So it kind of kills your standing issues. But anyway, so they went to the U.S. Supreme Court, And what Whole Women's Health had gotten from the district court, because now the Supreme Court's acting as the Court of Appeals, right? So they basically skip it up. And so now the Supreme Court's acting as the Court of Appeals. So what the district court said is, well, we're going to enjoin the judges and the clerks. We're going to put an injunction, prevent them from hearing the case, prevent from filing the case. And there's a fairly famous procedural case called Ex parte Young, which basically says in so many words, you can't do that. You can enjoin the executive, but you can't enjoin the legislative, and you can't enjoin the judicial. That's like not a thing. If the judicial screws up and they violate federal law, you can appeal that, but you can't stop them from hearing the case in the first place, not for the least of reasons that the judges themselves are bound by oath to uphold the Constitution. So you don't know going in that they're not going to, make the same decision the federal court would. I mean, there's no reason to think it, obviously. So the U.S. Supreme Court said, you can't sue the judges and the clerks because Ex parte Young. So just no, that's not going to happen. It says you can't sue the attorney general because they have no enforcement power, but you can't sue the guy because the guy says I have no interest in any of this. So, he doesn't count.
And you kind of have to take that at face value, right? His declaration there, you kind of have to, because I mean, what else can you say? Like, no, you're lying. You fully intend to sue under this law.
But you can sue the heads of the various health departments. So you can sue the head of pharmacy. The head of pharmacy was in this thing. The head of the nursing was in this thing. I think the head of doctors, the disciplinary board, a couple people like that. So you can sue these people. Now, for me, if I'm Texas, I think this is relatively easy because the way I read SB 8 and the clear intention behind SB 8 is to make sure that nothing in SB 8 can be brought up by anyone ever. Like, this is not a cause of action for the state in any context. And so that's the way I read it. So if you were trying to discipline a doctor, so this is the scenario, right? You're trying to discipline a doctor, you're trying to discipline a pharmacist because in some way they've facilitated this. And so now the state is trying to bring them before the disciplinary board because they violated SB 8 in doing that. If I'm the attorney general, it's real easy. No, they can't do that. SB 8 by its clear letter and clear intent says that the state has no power. That includes all these disciplinary boards. So if your basis for trying to discipline some doctor or some pharmacist or whatever is based on SB 8, just go away. You can't discipline them for that. So I think it's a really easy thing for Texas to just basically concede the issue and, go home.
Basically say
whether or not to do that, I don't know.
Basically say that's the law we wrote already. Yeah, we wrote a law which says we're not going to do anything. Now you're bringing a judicial action to try and stop us from doing anything. Well, the law doesn't empower us to do anything. We're not expecting to do anything. The executive branch in Texas is gonna sit mutely by, and it's a private right to the citizens to bring a civil claim against the doctors or anyone else who's involved, the pharmacist in theory. But that since the state is standing by, what? That's how the law is written. So now
However,
you want
Go ahead, Nate.
No. My whole thing is what Texas is doing to abortion is now what California has just introduced to do to the 2A.
Yes.
So exactly what's going on in Texas, California's just literally taking that legislation and said we're going to do it for the Second Amendment.
Which we called it, right?
I called that immediately.
It's good for the gander. Yeah. I don't even know what a gander is, but
a gander is a female
group of
goose.
geese.
A group of geese.
I know I'm just joking.
No,
Yeah.
Okay.
I looked it up.
So
a gander is a male geese.
I thought
a gander is a male.
Or is it female geese? Because a goose is a male goose.
Yes.
No.
Yes.
Okay. Now I'm confused.
I think a gander is actually
moving on.
And so was I when I was looking at this legislation, because I was thinking, before I got on with Kurt, I'm trying to read this and I'm thinking it's the substance, because we all want to argue about the substance of this, like whether this is substantially a good idea or not, right? In terms of the actual beef, right? We want to get into, okay, does this pretty much hampering, pretty much having a chilling effect on the ability of a woman to go and receive an abortion, right? Like, what's the actual impact on that right? So I think that's what we wanted to argue, but this was a procedure case. Like Kurt said,
Right.
it's not sexy, it's procedure. So we're going to get to the substance though.
One thing that was very interesting coming out of this opinion, however, is that there was a portion of the statute that has been effectively rendered obsolete, I guess you could say, which is the portion of the statute that says that only the woman can use constitutional rights as a defense, because the SCOTUS opinion did say that the healthcare providers can use they can use the Constitution as a defense for or they can. Sorry, I'm not saying this artfully at all.
Cause of action that they have standing. Sorry, they have standing.
Well, they have standing, but the actual claim that they can make is that they can actually defend against a claim on the basis of constitutional rights, that this is impeding someone's constitutional rights through the activities that they are.
Yeah, I mean, of course you can.
This is third party standing.
You don't need. Yeah, you don't need to say that, but it's. I mean, whether it's in the Texas Constitution or the U.S. Constitution beats statute. Mm-hmm. So if the statute says, "Hey, you can't raise this challenge," and the Constitution says you can, guess which one wins?
Rock paper Constitution.
And the pre-enforcement claim itself, so not even just in defense, but a pre-enforcement claim can also challenge the statute's compliance with the federal Constitution. So those I think were all things that the statute was trying to.
I don't quite think that. I mean, because again, the pre-enforcement challenge was for potential disciplinary action by these maybe you're saying the same thing as me or not, but this potential disciplinary action by these various medical boards against various nurses, which obviously hasn't matured, but the nature of the pre-enforcement wasn't for, conducting the abortion itself or in terms of liability under the statute. The only issue was disciplinary action.
Well, but in this case, though, I mean, they did maybe it was dictum, but they did say that they can use it as a defense as well, notwithstanding what the statute says.
Okay.
Yeah. So they can use it as a defense, even though the statute tries to prevent that from happening. So that'll be interesting if any of these entities do end up getting sued, or if I don't know how many of them have actually been sued at this point for doing any abortions. I know there was one doctor who wrote publicly that he had conducted one, and I think
which obviously now he has a real case. He has a real controversy, so he can bring that up, and he can bring defenses into the district court, and then he can appeal that issue, and he can even appeal that to the federal courts because ex parte. Young. What's the other one? I've had a brain fart.
Oh, Grupo Mexicano.
that's not the one I wanted now. But yeah, they can do that. They can bring it to federal court because there's federal issues for review, so it should be fine.
Yeah. So anyhow, that was an interesting opinion that came out, and
also, by the way, just as a side note, there was also a parallel case called U.S. versus Texas, where the United States government sued Texas for violation of the federal Constitution, violation of federal rights, and that got what we call dismissed as improvidently granted. The Supreme Court never heard this case. We don't know what you're talking about. So yeah, the Supreme Court bounced that and said, go away.
That was very interesting because I remember going through the briefs with you, Kurt, on that one. And that was going to be very interesting to hear, the supremacy clause issues there with the Supreme Court and whatnot. But I wonder if they were like, the stakes are a little bit too high on this one. Let's make it go away.
We don't want to decide that issue right now. This is a vehicle, so let's do that. And the vehicle could get mooted, by Texas instantly if they're so inclined, is the way I see it. So the one that's left is the one with the doctor who actually has a live case in controversy.
Yeah.
And they said there's I think it was multi-county or multi-district.
Yeah, I got
litigation
confused there too.
Within Texas,
Yeah.
challenging this. So this is going to be challenged, right? We're going to get a resolution here, and I hope, frankly, because of exactly what Nate said, because they're going to try this in Texas, they're going to try this in New York, they're going to try this to infringe upon the 2A. This is a bad idea, and we all said this, by the way. We all were like, this is bad precedent because we don't want this tit for tat, right? You go after our right here, we go after your right here. This is a bad road to go down. So let's just not go down it.
And that's exactly what happened. Governor Newsom came out with a whole statement about it on I saw it on Twitter. It was like the day that the Supreme Court came down with their opinion, and they were like, and the Supreme Court was like, oh, by the way, we're not issuing a stay on SB 8, so it's still active in Texas. And that was his response, which was completely predictable, right? Like all of us predicted it almost immediately when we saw this law. So,
but just understand that the news articles that say that Roe is over, Roe is overturned, Roe is gone, that is complete hyperbole as of date, right?
Yeah.
That's complete hyperbole.
Yeah.
As of right now, maybe like
As of today.
Let me get my kids ready for some lunch because they've been waiting here for lunch. I'll be back.
All right.
All right,
Sure. All right.
So the substantive abortion case is, who is it versus Jackson in Mississippi?
Whole Women's Health versus Jackson.
Is it Whole Women's Health? So I thought
They're
it was Whole
everywhere,
Women's Health.
baby.
Yeah,
They're
and I thought it was
everywhere.
Whole Women's Health. I just didn't want to say it. It sounded like an idiot.
No,
yeah,
it's
Whole Women's Health versus
Health.
Jackson coming
I
out
felt
of
like an
Jackson,
idiot.
Mississippi. Yeah, coming out of Jackson, Mississippi. That's a substantive case trying to overturn Roe. And it seems, based on the oral review, because we've done that analysis, it seems like they're looking to modify at least a bare minimum Casey, which, fair enough, because Casey is a bit of a garbage opinion because it's a fractured opinion. It's one of these opinions that has, different people voting for different things, and you can't really get to a
Different
true majority
sections.
for really anything. And
2A,
you have to splice.
3C.
Yeah, you kind of have to splice everything together and try to figure out what's going on. It's not a great opinion for that reason. Hard to figure out what it's talking about. And then it uses this undue burden in viability, and the courts, God knows, have tried to struggle to figure out what the heck that is.
Yeah.
So I think overturning Casey and maybe replacing it with something else would be fine. Whatever that is. The real question is, and then the question is, okay, so if not viability, do we set a different number? Yeah. And setting like a hard week number would be at least easier to administrate, because like if they pick just as a statement like 20 weeks, if they say, okay, 20 weeks is the line, then that's easier to administrate, because that's a hard number. We know exactly what we're talking about. So the real question beyond that is, do they get to the substantive Roe and say, well, we're going to overturn the right to have an abortion, which, as I like to point out, even Ruth Bader Ginsburg herself said Roe is not sitting on good legal foundations.
She did say it.
Yeah. It's not. I don't know where you get that from. Now, the Supreme Court did raise a reasonable question, to which I didn't find the answer very satisfying. But the question was, okay, well, if you do that for Roe versus Wade, how about other decisions that are kind of along the same lines at the same time? Perhaps the most obvious of which is Griswold versus Connecticut. So Griswold versus Connecticut, at the time, Connecticut had a ban on birth control for everybody. There was no birth control in the state of Connecticut. So they were very conservative at the time, I guess. Or very Catholic, take your pick. Either way. So Griswold, married couple, sued and said, well, we have the right to contraception as a privacy. And then the Griswold decision itself said, yes, married people have the right to contraception as a right of privacy. Now, the problem is, where do you get that from in the Constitution? It's not there. Not for the least of reasons that contraception wasn't really a known thing when the Constitution was being written or the 14th Amendment was being written. Didn't really exist that much. Not to say that there haven't been methods tried, but what we're talking about in modern contraception, not really a thing.
And that said, try to find a substantial population in the United States that thinks that we should go against Griswold v. Connecticut, right?
Yeah. So that's
that we should be able to ban birth control.
So there's other decisions like that. So do we tack those? Do we tack those too? And the answer they gave, which was a little unsatisfying, was like, well, this is the only thing that deals with loss of life. And I'm like, because that's not really a great answer, but it's like, I got nothing better, so why not?
Mm-hmm.
Yeah, I see the, like you said, Kurt, I see a modification of Casey, not an overturning of Roe. I mean, or an overturning of Casey, not an overturning of Roe, as being a little bit more likely.
Yeah, no, the overturning of Roe is where we get our big waivers on, big balls.
I think one thing we just got to be mindful of, and I think I've talked about this with a lot of people, is that the technology is advancing. So, the rate at which you can, for example, keep something alive at a sooner point will just become sooner and sooner, right? So at what point do we set a static mark and say, okay, we're at 20 weeks now. All right, well, in 50 years or 100 years, are we still going to be at 20 weeks? Are we going to be at 10? Are we going to be like, where are we going to go?
Yeah.
When they invent the artificial womb, what then?
It'll eventually happen.
We're all living in the red-pilled version of the Matrix, and we're actually just, breeding centers for the robots.
I mean, eventually, right?
But balanced with that, no, I do agree, because the issue of viability, it's at the time that it came out, science was at the level that it was at, but science continues to develop, and we continue to get better and better tools to see and understand the world. But at the same time, you also have, women aren't necessarily any better at detecting when they are pregnant. Let's face it. It's hard. It's hard. Like that is even like measuring how many weeks pregnant that a woman is. It's surprising, because it's not actually from conception. It's from the date of your previous cycle.
Yeah, that's true. That's how they measure it.
Which could be as much as almost 4 weeks before that point, or more if you have skipped a cycle. So there are so many ways that gets very tricky and seemingly not very scientific, which is one of the things that makes issues like this, like bringing it down to 5 weeks, very, very problematic, because I have known of many women that did not know that they were pregnant until 8 weeks. In fact, in the briefing, they went to some length to prove that, and I thought it was very convincing. Mm-hmm. Whereas, basically, the only woman who would know is a woman who's basically actively trying to get pregnant, and so is monitoring this on a really frequent basis. Otherwise, by the time you figure it out, by the time you can get it, it's there's no interval. You're just too late. And I was like, yeah, that makes sense. There's just no time. Yeah. So yeah. No, I definitely agree. Virtual loner, he wanted to clarify his earlier super chat. In my earlier chat, I meant that, or he or she, sorry, I'm assuming genders. In my earlier chat, I meant that it was an unconscious reaction to pull the gun and not the taser, since the gun is on the dominant side of the officer. Well, that I think makes sense, because your dominant side, your dominant hand is maybe the one that you feel more comfortable drawing with.
So that's making it less negligent. I
think so. I think making it more, making it, I guess, less unreasonable to draw a gun in that kind of a situation, I suppose, is the point. Which I can see that argument coming into play. But in order for the defense to use something like that, they would need some kind of an expert to testify to that. But I don't know that that's something that they would be willing to put forward as an argument when they have other arguments that are maybe a little bit stronger.
It'll come up during the civil case when Kurt is arguing in defense of Potter in the city. That's when that'll come up, because then you're portioning it out and you're saying, oh, it was a little bit more reasonable, right? But in the criminal side, like you said, Legalbytes, it's not relevant compared to other issues. They have some fundamental problems with this case.
Yeah. So, well, anyhow, I think we covered that case pretty well. You guys want to move on to the next one?
Let's do it.
There was just one question I wanted to address in chat. Yeah. Someone asked what would happen if Roe was overturned. So, what happens if they
breaking loose?
Well, other than the potential protest / unrest that might result, let's talk about the law. So, if Roe is overturned, then it just reverts to state control. So there would be no federal law on the issue. It would be purely state. I think something like 22, 24 states have laws that basically instantly ban all abortion if Roe gets overturned. Something in that order of magnitude.
22?
It's something like that. It's something like that. It's some number that's close to 25. It's
non-coastal states. Let's put it that way.
Yeah, it's non-coastal states. Yeah, so it's like 22, 24, something like that. States that instantly would ban all abortion. Some would ban to different degrees. Some would remain wide open. California apparently was talking about giving out, making it easy, giving out hotel rooms and paying for
Subsidies.
travel and stuff like that with taxpayer money, incidentally. So like, okay, I guess that's one way to spend your taxes, California. Sure.
California
so yeah,
has
it would
a
just
lot
revert
of
to
ways
state
of
level
spending
control. It
taxes.
would be a state by state thing, and we would basically have the battle we were denied the first place. I continue to maintain that even if you think Roe was correctly decided, it was a pragmatic fail, because at the time, I believe 4 states had abortion, and I think one of them was Alaska for some reason. But I think it was like Alaska, Washington, maybe Illinois, and there's like one other. So of the 50 states that we had, only 4 had abortion. So you're basically overturning 46 states, and you haven't been able to convince people through the legislative process. So if Roe had never happened, what would have happened in the various legislative processes of the various states? Who knows? Who knows? Maybe the states would have been convinced, but they were basically denied the chance in the first place. So then becomes the long, hard slog of actually persuading people. Whoa, So
Yeah.
who knows what will happen in the future?
Yeah. So yeah, and that's a very good point, that there are a number of states that nothing would change, like California and New York. Nothing would change for the standards of abortion there. But in other states like Texas, SB 8 makes that very clear, that if Roe were to ever be overturned, then it goes back to whatever the Texas laws were at the time on abortion, or in this case, it would be potentially modified to SB 8. So I imagine that
How about this? How about can we get a ruling from the Supreme Court that birth control has to be offered over the counter in all the states? Because that way you could get it. That's what I think. Yeah,
that's how it is in a lot of other countries. A lot of other countries, it's over the counter.
And the only reason that seems to pop up for why birth control should be not over the counter is because, well, if women weren't able to get through, if they only could get through prescription, then that means it would come in and we'd be able to examine them and make sure. It's like, but man, who are you to be that paternalistic to women? It's like, maybe they should come in for their exams, and stuff like that. But, that's their choice. If I don't want to come in to see the doctor, screw you. If the medicine if it's not going to cause me harm or side effects, screw you. It's like, it'd be really good for you to come in so you could get that prescription for aspirin, so we can make sure about your general health. No.
Yeah.
So if we could get birth control over the counter, that would be great. And Walmart incidentally sells birth control off with no insurance for $4 a month. So just a FYI there.
In case anyone's looking for it.
Yeah.
No, and there are potential side effects with birth control. Headaches, it can cause,
depending on
cause strokes.
You have, right?
I have a very good friend who in college had a pulmonary embolism, and part of it was because she was on birth control. So
wow.
there are risks to it. She was also on a very long flight, so it was the combination of the two. But she was a very healthy person, was a student athlete and everything. So it's kind of shocking that happened to her. So that is a possibility, that kind of stuff, and actually, I remember several years ago, I saw something about how someone had done test trials on basically doing the same sort of medicine, but for men instead of for women.
Oh, no, it doesn't work. It kills your teeth. They haven't invented one that actually works for men.
I don't know that it didn't work, but what
there
they
was
were
that
saying
gel stuff that
the side effects were too risky
by lowering your testosterone levels, and men in the United States already have historically low testosterone levels. So the issue is it pretty much makes you completely sterile, right? By pretty much like upping your estrogen levels and killing your testosterone, which will cause you to stop producing sperm. It will make you, it is birth control, but it's extraordinarily horrible. The side effects are horrible because, men having low testosterone is horrible for men, like absolutely horrible. There's lots of bad side effects, which is a difference with the genders, which was once again a huge debate, right?
I mean, it does wreak havoc on women's hormones too. I will say that.
Yes.
There was this Vizio gel that I think was being developed in India. I don't know what happened to it, but it looked promising, where they would inject a gel into the vas deferens tubes. And what I understood is that the gel was kind of like a matrix or something. And so as the sperm would come through, basically it would overheat and die because of the nature of the gel. So it could also be flushed out with saline solution. So it's basically like vasectomy without, the more permanent repercussions. So that looks promising. I don't know whatever happened to that, but
Well, you think there's I think now there's over like 50 or 75 different types around the world of, female birth control, but we haven't had one male birth control that's like actually effective and like doesn't have horrible side effects. It's like, I think we're not trying hard enough. Like, I think there's gotta be an option besides literally a piece of plastic, right? Or, a vasectomy. Those are your options right now.
Yeah.
And by the way, we have no option for, and I'm very passionate. I mean, we have no option for, our financial, as I call it, financial abortion, which is completely, I think
that's always a fun discussion.
That's a great discussion because there's a good reason why people aren't getting married anymore. And there's a good reason why people aren't having families anymore. And there's a good reason why guys are not willing to take the risk anymore. And that's something I hear about all the time.
Well, with the inflation numbers looking the way they are, the Great Depression coming all over again,
Yeah. Oh, a kid is a great thing right now. Yeah. A kid is a great thing right now. In addition to student debt and recession and eating the bugs and, fried chicken,
Well, this is why millennials are having kids later and later right now, right?
Yes. Are you a millennial, Alita?
Yeah.
Okay.
I'm technically a millennial.
I am. Why?
Wait,
really, Kurt?
I was born in 81.
Yeah.
That's the edge. You're on the edge.
Hang on.
I'm on the edge of the edge, man. I was born in January of 81.
Now you're in this dangerous territory. How old do you think I am?
Hold on. I thought you could be Gen Z.
Oh.
I've played this game before. Don't worry.
This round.
Is it scary that Gen Z can actually drink now?
Yeah.
People who were barely alive during 9/11, like they were infants, can now drink.
Andrew, how old are you?
You never ask a gentleman his age.
Of course you do.
38.
No, I'm 30. I'm 35. 35.
Oh, okay. So I am the youngest law tuber.
Thanks for making me feel old. That's great.
Grandpa Kurt over here. No, actually, it's funny. Ron Coleman was in my chat today, and I said Ron Coleman is truly the dad joke. Like, he is the dad of the legal sphere because he's always got the dad jokes. Like,
he
all
does.
The time. I love it.
He does.
Now I want him to throw me a bar mitzvah.
I think you have to be Jewish for that.
Well, I had a stepmom, but anyways, we'll go down. Not go into that.
It's America. You can do anything you want. You're free.
I can identify.
Don't let Alita set limitations.
Where's Joe? I need to talk to Joe about this. Can I identify as Hebrew?
I don't know. Grandpa Joe had to go. He got a phone call. And I say, by the way, guys, I'm not saying that as a pejorative. He is literally a grandfather. I found that out recently, and
crazy,
it's one of my favorite facts about him. So yes, he is literally Grandpa Joe, and I love it. It's wonderful. So shall we talk about Jussie Smollett again?
Juicy
sommelier.
If that man doesn't get at least some time, I'm going to be sad.
Yeah, a lot of people are going to be sad if he doesn't.
He needs to get some time. Like some just go send him to jail for a week. Like, he's going to have a breakdown after 1 week.
Yeah. That would be good to see. I think a lot of people would be very happy to see him spend at least some time in jail. And I do agree, because you know what, he did make a complete mockery of the legal system, the judicial system, and how many resources in Chicago PD were used for his case that are maybe overstretched for Chicago, because of course they are the Chicago, of course, is the safest place in the world, right? The safest city in the United States. There absolutely is no gun violence, no murders, no nothing. The police officers there are for sure not overworked. And they were required to dedicate time and resources to his non-case. So yeah, that is infuriating.
Well, there's two aggravating factors to my mind. The one is he took the stand and perjured himself. It must be true that he perjured himself, because the jury found him guilty. So it must be true that he lied. So that must mean he perjured himself implicitly. Right. So that's one aggravating factor. And the other aggravating factor is, if we remember at the time, if we go back to that time, there was quite a bit of tension in the United States as it relates to race issues that are not quite as prominent. Yeah, not quite as prominent now, but there was a lot of tension. It basically came in the very heart of that. So he basically tried to start a race war. And I think he at one point said, I don't care if I start a race war or not. So it's like, okay, well, that's great. So my view is, generally speaking, and there can be exceptions, obviously, but generally speaking, when you do a criminal thing, you take responsibility for all the things that happen. That are, you roll the dice, and sometimes you get lucky and sometimes you get unlucky, and you should absorb responsibility because you're the one that did the bad thing to a large degree. And I feel like this is that situation. It's like you made this. It's even worse than that because it's not rolling the dice. It's like you should have known. It's like this is betting on the roulette wheel after the ball has fallen or after the ball has stopped. It's like, yeah, you really should know what's going on here at this point in the game. So when you did that with that purpose in mind, and I also continue to think he faked the letter.
Yes.
I think he faked the letter.
I think so too. Yeah, with the newspaper clippings. Yeah. It looks like he wrote it with his non-dominant hand.
Please, federal government, prove it. Please, federal government, prove it. We can get him for mail fraud. It's 10 years.
Oh,
It's great.
That would be great.
Here's the thing. Go ahead.
I was going to say, Neil wanted to know if they can go after him for perjury if he keeps going. I think not, because he has the right to to make his argument, to keep
doesn't have the right to lie. We as lawyers all very well.
But I mean, if he wants to appeal the case, he can continue to maintain his story, maintain his narrative, and say that I'm appealing this decision. So then that's a legal argument that can be made, that it wouldn't result in like further charges. He can still maintain his innocence in the face of a conviction.
Yeah. So perjury is only a sworn statement, so that'd be only something that comes up in court. But I think the bigger thing I'm worried about here, and people have said, I think there's another super chat talking about him cleaning up graffiti in Kenosha. I'm worried that it's not even going to be that, because most analysts are saying because it's a first-time offense, he's just going to get community service. My thing is, he's going to make a mockery of it. I think if you just give him community service, you know what he's going to go do? He's going to go to some like anti, like LGBTQA++ anti-racism thing, and he's going to go to that and go do community service there and still hold himself out as a victim, right?
Yeah.
I mean, it's not going to show any punishment for this. There needs to be a deterrent effect here, because if there's not a deterrent effect, there will be copycats, because they're going to say, oh, what's the worst I have to do? Some community service for my, for something that I'm a part of, for an organization that maybe he's even part of, right? He's able to do community service for an organization that he supports, BLM, something else, right? He needs to do the time, right? That's the only thing that's going to make people like that think twice before they commit an exact similar crime. And they're just going to be better about it. They're not going to hire Nigerians this time, right? It's going to be a little bit different. Or
probably pay them by check, and
right,
2 a.m. in the morning, and talking about making out with them. I mean, it's just all weird stuff. It's so weird.
Well, Hunch the Dirty Roofer says that better than jail, make Jussie attend the police academy, and that passing is contingent on commuting a further punishment like a stint in jail. I think that sounds like a premise to a really funny movie, like Police Academy. How many Police Academy movies were there in the
19? No, I'm joking. There was a lot.
There were like 4 of them, right? That would be funny if they rebooted, starting with this, starring Jussie Smollett.
I love that concept in general. I have to tell you, I think we're too locked in to like send them to prison. I think we need to be far more creative in how we punish people.
If Martha Stewart goes to jail, Jussie goes to jail. That's all I want to say about that.
In Florida, we still have a town that requires you to go out there and hold the sign in the middle of the busiest street in the town that says whatever your crime is. So if you stole something, it literally says, "I am a thief."
Beautiful.
I'm like, I love that. That's like some biblical stuff. I like it. That's like, no, you're with me. There's some Leviticus stuff here. I'm loving it.
Let's do it, brother. If you start getting medieval, like that's when they also like were cutting off ears and noses.
I'm not talking about that.
Not that stuff.
Public shame.
Not that stuff. But I would be down for talking about bringing back the pillory. Maybe throw a tomato. That'd be cool. Yeah. As the Supreme Court once reminded us, in Washington D.C., they used to have pillories up and down the street. It's like, bring that back.
I mean, we have it. It's just all on social media, right? Mm-hmm. Well, it's going viral for a mistake.
Yeah, except for it's all because social media is so tilted that there's no shame that's brought to these people from social media, right? That's the whole point here, is that these guys are not being. Instead, it's their truth, right? And their truth includes perjury. Right. So it's all whack.
Yeah. And Nernith says the only way to correct a bad habit is to form new ones, have the punishment be them doing the opposite of the crime. So what would be the opposite here?
Wearing Joe's MAGA hat? I don't know. Like, what do you got? Like,
I love it.
you know,
Like he needs to be wearing a MAGA hat and beating some other person up himself.
No, not beating somebody up. Yeah.
I guess not beating somebody up.
Giving them a
Yeah,
hug.
maybe volunteering at a soup kitchen wearing a MAGA hat.
Yeah, that could be really amazing.
Spending a night with Rambo.
These factors are just so much for me. It's like I really am hoping for a year in jail. I probably will be disappointed, but that's what I'm hoping for.
I'll take a
Yeah.
month.
Yeah.
I want a year.
But
I want 18 months. Judge on civil law is thinking 18 months sounds pretty good to him. But I'm waiting to be disappointed.
Right. But did you guys hear about the juror that spoke out to the media?
Yeah.
It was the one black juror that was on the jury, and he spoke out and talked about how he was absolutely convinced that Jussie lied, and that he said his point was like, hey, look, I'm black, but that doesn't mean that I'm always going to side with a black defendant, which was a very, very good point to make. Because people are not monoliths based on their demographic, right? Like not all women are pro-choice. Not all, women are even pro-life. Not all, not all black people are going to automatically side with someone like Jussie Smollett. So, and that's a very interesting point and a very good point. But I don't know. Did you guys read about that at all? About this juror?
Yes. And here's the funny thing, though. The sources, it depends on what you read, because there's sources out there, and you see them on Twitter, all the liberal sources, all the CNNs of the world and all those, that are saying one black juror said that, they felt pressured and they would have gone another way, and they were framing it that way. But you read even a neutral source, and they're like, nope, they said they thought he was guilty. And in fact, they said they would have convicted him on all 6 counts, except for they were confused by the jury instructions on the 6th count. So they didn't understand it properly, which is why they found him not guilty. But they thought he was a lying piece of shit. And they found the Nigerians very credible.
Yeah. Yeah. And that for me fit into my theory that I started to develop, which is that these jurors that are on these high profile cases, when they are coming to a conclusion that is the opposite of the media narrative, especially, they tend to take a longer time because they want to be very thorough with the jury instructions, which I think is just kind of generally true of juries, generally speaking. A lot of times they do like to be very careful. Like, I remember my dad telling me about when he was on jury duty for I think it was a DUI case or something. And he was like, yeah, we went piece by piece and it was very logical and very methodical. And I think we came to the right decision. And so I do think that that's common, but I think that it also, in these particular cases where they know very well that there are a lot of people paying attention to what the jury is going to conclude. And if they're going to conclude something different than what the media narrative is, they're going to take extra special time, I think. So, yeah.
Media sucks.
That's why we're here.
We are media now, damn it.
We are, but we're independent media. We're different.
You're now alt-right media.
No, we either die the villain. We either die the villain, right? Or live long enough to see ourselves.
Yeah. You've got Joe from Good Logic on. I mean, come on, man, come on.
I know he's got his NYPD hat. He likes to switch out to a MAGA hat.
I don't even own a MAGA hat.
Or what else do we have on the agenda for today?
So other than that, we have Jana Duggar. Do you guys know anything about her?
Yeah, that's Duggar's half sister or full sister.
I think full sister. Well, let me just get this one super chat before we transition. So Legal Mindset, I definitely think Jussie should get massive jail time, at least 5 years. I just thought making him do what Kyle Rittenhouse was doing, cleaning graffiti, would be ironic. It would be.
I see it, and I agree with Kurt. I think there'll be massive jail time. I just, I try to be realistic. On my channel, I don't. And here, whenever I come in and give my opinion, I try to be realistic about it. I think he should get massive jail time as well. I agree with Kurt.
I think we need for now, so I'll talk to you guys later, man.
All right. See you, Kurt.
Later. I think we need Isle of Elba type of thing. Let's buy Greenland.
From Denmark.
We used to have Australia for a loaf of bread. Yeah. We buy Greenland. Have him living in like cold climate with no cell phone service
and no subway.
Not no cell phone service. really, really bad cell phone service, so that they spend like part of their punishment is that they're constantly trying to get online and just like, no, where's my service? Like that's an appropriate time. You don't need to put them in jail. There's a lot of better ways to punish people.
There are some creative ways you can do it. Austin SA says, since Nick is too big to read his super chats now, YouTuber Goldshaw is crossways with hound hunters. Vermont law allows unattended packs of hounds to hunt across property lines. Any taking implications? I think that probably has more to do with whether the state is a fenced in state or a fenced out state. So when it comes to, I think that usually has come out traditionally from people managing their livestock. So whether they have a duty to keep their livestock fenced in, or whether individuals who don't want livestock on their property have a duty to keep livestock fenced out. They have a duty to put up a fence to keep them all out. My guess is Vermont would probably be a fenced out state based on what this is saying. So I don't necessarily think that would be a taking issue, because
there's no actual taking of the property, because it's livestock doctrine, and it's just a belief on how you feel livestock should be allowed to operate, right? Do you feel like you have a duty to control them, or do you feel like they should be able to graze wherever they're allowed to graze, right, in the commons, right? And you've got a duty to wall them out. Like that's a philosophy, but it's not a taking, because there's no permanent taking of the property. Now you can argue that the fact that they eat the grass is a taking, but whatever. That's
what the heck are you? Where are you practicing that? Livestock law.
Oh, I did a lot of wildlife law. I've done a lot of wildlife law. I
just know this from law school.
There's no lie. I didn't even. When you use that phrase, what did you call it? Livestock law. I didn't even know there was such a thing as livestock law.
That's because you live in New York.
Florida
you haven't lived in the flyover state.
My first time on Nick's channel, he started talking about tree law, and I'm like, what the hell? What the hell? That's not a real thing. I mean, I know. When it get weird, there's maritime law. Okay, but that's something that's a phrase we've had for several centuries. So I get that one. But livestock, I mean, what do we deal with? Cattle rustlers and livestock law?
Yes.
Is it really? Is this what we do?
It literally is. Because
we
back
do
in
cow
the day,
tipping and livestock law. Yeah.
Well, just the movement of livestock across the grounds, because different states wanted to either encourage or didn't necessarily feel a need to encourage the growth and movement of livestock. If you consider a place like Montana, that's probably a fence in state, right? To say that, or a fence out state, to say that, if you don't want livestock on your property, build a fence around your property, because otherwise it's going to go around wherever it's going to go around. Like you have the burden of keeping stuff out. I don't know if Montana is actually like that, but that would be my guess, because that's kind of one of those places where there's a lot of big animals that are roaming free. So that's, it depends. And let's face it, livestock is a very big industry. You go to Texas, like they have a lot of cattle there to sell for, so you can get your nice New York steak, Joe.
If you ask me where meat comes from, I say the supermarket. Okay, I don't need to know beyond that.
I got crazy with it when we had that gator case at Disney, where the kid was eaten by the gator, and everybody.
Was that also part of livestock law down in the parts you're from?
You can keep gators and you can maintain them, but you got a certain duty to remove them over a certain size. But there's also no duty to warn, because they're a native animal.
I was wondering where my wife's purse comes from. It's from your gators, I guess.
Pranav Ocha, I'm sorry, I hope I'm pronouncing that right, says, make Jussie Smollett make a biopic and play the role of Thomas Sowell or Walter E. Williams.
Oh God, those guys are on the Mount Rushmore of based African dudes.
Also, Joe, it looks like you're failing on your studies here, according to the John Beck. No livestock law, Exodus, Leviticus. Turning you yarmulke.
Yeah, I'm dealing with American law here, and it wouldn't be classified. There's no section, there's no tractate of the Talmud referencing specifically.
Just called you out.
Got him.
Like, you Hebrew grifter, get out of here.
I'm sitting here. I'm struggling. If you're wondering why I keep looking down, it's because I just got
frustration.
Yeah, I just got a new case for my phone because my old one was, and it's not fitting on here, and I'm not sure. I bought a case for an S10 case, and my phone is S10 Plus, and I'm trying to figure out whether this thing is just too small. The rubber is too small. That's basically the problem I'm dealing with here. That's the problem. The rubber is too small. So,
Well,
and I don't know.
a lot of people have that problem sometimes, I guess.
Yeah. Well, so that's what she said.
I got him. He was never expecting me to come out with that kind of a joke.
Oh my God!
We did not plan it. From you, no, we didn't see that one coming.
First it was Andrew so I'm on with Andrew Branca, and Andrew Branca calls the judge in the Kim Potter case mommy. And I'm like, where are these people? First we infected Viva with hentai, then mommy, then you with rubbers. I mean, this is going downhill fast. Next thing Joe's gonna be eating pork down there. Like, what are we gonna have going on? Like, this is a bad influence on everybody.
You guys are bad. Yeah, so I'm just trying to figure. Maybe your audience knows whether there's a difference between the S10 case and the S10 Plus case. That's my question, because I assumed it was the same, and I'm wondering if maybe the reason my rubber is too small is because I wasn't accounting for the size of my phone. So
I can't. What's the next topic? Keep moving, please. I can't even look at the chat right now. It's gonna kill me.
Billy tells me wants some interview karma. He's got a compliance gig. Yeah, good luck.
Oh,
good
awesome,
luck,
man. I worked in compliance. I was at one point in one of the companies. I was head of regulatory and compliance. So it's really boring work, but it's very predictable. So you should be able to.
Hey, that's good. So let's get to so speaking of moms, let's talk about Jana Duggar and child endangerment. I don't know if it was unclear to me based on the articles that I was reading about it, whether it was actually her kid, because it looks like she was babysitting. So I don't think that it was actually her kid, but that maybe it was another child that she was watching at her home while babysitting. But basically this came right on the heels of the Josh Duggar conviction for let's say it for owning and obtaining material of minors that is of a prurient nature. We'll call it that. So he had his conviction, and now they're going to be waiting for like 4 months for his sentencing. But right around that time, apparently his sister Jana Duggar was charged with child endangerment, and so I had some people asking me about it, so I figured we would talk about it. Apparently there was an incident that happened back in September, but she was just now charged, and I don't know about the timing of it. Maybe it has something to do with the fact that they're just like, well, let's just hit this family again.
So remind me of the facts on this one, because I know Duggar, tons of children. Someone in the chat said Jana doesn't have children. I doesn't have kids. Like, yeah, so how is it child endangerment? Well, who's child?
30,
children?
She's okay. So she's unmarried and has 0 kids. That's what Shannon Worshing in the chat says. Which that sounds about right, I guess. Because what the articles were explaining is that she was babysitting at the time, and I guess someone was driving by and saw that there was a kid out on her front lawn that had gotten outside. It's very, very simple factual scenario. And they called the cops on her, and so she says that she just had turned her back on a moment. And I think she had several kids there. She may be running a daycare out of her home. There are a lot of people in the United States that do that, that run daycares out of their homes, or have their kids go to a daycare that's like a residential property. So it sounds like it was something along those lines. And she turned her back for like a moment. This kid was outside. And then the I guess the cops or child protection agency or somebody came by to investigate, and she got a basic citation for it. So child endangerment can run the gamut between a misdemeanor and a felony, depending on how serious the charge is, or how serious the facts are. Because it can be something as simple as being leaving your child somewhere in an area that is that is unsafe or nearby some sort of weapons or, dangerous equipment, or it can be leaving your kid in a car on a hot day. It can be all kinds of situations, or leaving your kid with someone that is a dangerous person. That's another one. But in this kind of a case, it seems like it's a very, very simple factual situation, and it seems like it's maybe being made into something bigger than what it actually is, according to the reporting.
Anytime there's a celebrity, it's going to be blown out one way or another, right? Either you're going to have them make a big deal about it, or you're going to have people come out to simp for them, like Alec Baldwin, right? We had everybody coming out and must protect. It's like anytime it's somebody they like, they run out to protect them. Anytime it's somebody that they don't like, and at this point the Duggars are not liked, right? They're going to run out and attack them, because it's sort of that instinct to, either idolize or tear down those that are in a high social position.
Yeah.
I think perceived celebrity.
And I think in this particular case, there's also the added element of, like, she has a brother that just was convicted of inappropriate, handling of materials that are, that involve children. And so this is another situation where that does involve children. So I can understand that people seeing the connection there and getting very, very alarmed in a case like this, because there's been some issues going on there in that family, it sounds like. But it seems like in this case with her, it seems like this was probably just something that was a mistake. She got a citation, which is not unlike, technically when you get a traffic ticket, you get a citation. Technically that is a criminal violation. Right. So, it's not unlike something like that. So, a lot of her siblings have come to her defense recently on social media, which is not terribly surprising. But that could mean just about anything. It doesn't necessarily mean that she did the right thing. It could mean that they just are standing by their family member. But yeah.
Yeah, I mean, it's something, like I said, it's real. There's charges like that go on all the time, right? It's not like she had some sort of scheme or concoction, and it's certainly not like she's a Ghislaine Maxwell. And that's a situation which, our boy down there, Joe, has been doing a great job of covering, because, that's a situation that, hey, we shouldn't be talking about the Juggers. We should be talking about the actual child sex rings that are going on and need to be covered and aren't being covered by enough people.
Yeah. Yeah, that's fair. That's fair. So on that note,
is that your segue? That was really.
Did you like that,
Andrew? That was impressive. That was very
really good.
I love you, Joe.
Thank you. Thank you very much.
Yeah. So Joe, what's the? I think since you were on the channel last week, there was like one day of testimony. Since then, it was on Friday, and I know you were there for like half the day because you had to go for
any farmer.
Sabbath.
Any farmer took the stand.
Mm-hmm.
Yeah. So how did that go?
So before she took the stand, and I addressed this on my stream last night. I actually was in the middle of clipping it when I was like, oh my gosh, I got to start getting stuff done for Legalbytes and get on our show. But so before she took the stand, the judge gave the same instruction that she gave when Kate took the stand. Kate is a pseudonym, Anthony Farmer is a real name. And that was telling the jury that the court anticipates you're about to be hearing testimony involving sexual conduct between the witness and the defendant or Jeffrey Epstein. And you should bear in mind that all of the conduct that is described in this testimony is completely legal. And accordingly, you should not use any of this testimony as the basis of your convicting the defendant or of drawing any character, taking any inference of it about the character of the defendant, which was a very interesting. I mean, it's the same thing she said by Kate. And I spent a lot of time, like last week, a few days ago when I was covering this, because we have a break, and I started actually looking more closely at the law around this case and what's happening here with these statutes. And the question I had is this: if you pull up the Mann Act, so we're looking at 18 U.S.C. 2422 and 18 U.S.C. 2423. So those are the crimes with which Ghislaine is charged. And the way the charges are laid out is they say, with respect to this charge, we have victim 1, victim 2, victim 3, victim 4.
Mm-hmm.
And it says that these activities were taken by the defendant with victim 1 as follows, and then with victim 2 as follows, victim 3 as follows, victim 4 as follows. So clearly the state was under the impression that Kate, all the activity with Kate, all the activity with Annie Farmer was something that could lead to a conviction when there was an indictment. And somewhere along the line, presumably during the course of this trial, because it doesn't seem as if there was any decision, knocking them out earlier, somewhere along the line, the court said, no, that cannot support a conviction. The question is why, right? I mean, I think it's a fair question. I mean, the basis that she's saying is that they were over the age of majority. That's what the court said, meaning Kate was transported from England to New York. She was 17 at the time. In New York, age of consent is 17. And accordingly, she's not deemed sexually a minor. Maybe she can't vote. Maybe she can't sign up and enlist in the army. But sexually, as the age of consent, she's not considered a minor in the state of New York.
Right.
Annie Farmer was transported from Arizona to New Mexico. New Mexico's minimum age for consent is 16, and that's how old she was. Accordingly, they say you cannot convict on the basis of, her being a 16-year-old. But that begs the question, which is, well, how did we get this far that they were never knocked out in the first place? Shouldn't they have been knocked out in the first place? Like, what's happening here? Either they can support a conviction or they can't. So what the heck is happening? So I started looking at this a lot more, and particularly the motion. There were 12 motions brought by the defense to dismiss, and they started arguing. They were arguing on the basis of statute of limitations. And so what's the statute of limitations on the Mann Act? Well, it's actually the lifetime of the victim. So what's their claim? Well, their claim was that the Mann Act originally lasted for 10 years. And then in 2001 or 2003, thereabouts, the Congress passed the PROTECT Act. And the purpose of the PROTECT Act was to extend the statute of limitations and say, okay, now that when we're dealing with child victims of sexual abuse, we understand that there are bases as to why it is a child is going to take a very long time to come forward. And that's why we're extending that beyond the 10-year statute and giving them their entire lives. They have a psychological issue, there's psychological damage, there's dominion and control by the person taking advantage of them. They might have fear. There might be a million reasons. So they say we're going to extend it out. So that's why they said now the Mann Act, which is the act that was passed all the way back in 1910 about trafficking children for illicit sexual purposes. So that basically makes it a crime to cross state lines for the purposes of prostitution or touching a minor in an inappropriate way.
So it's the language. I pulled it up. It does says, Joe, I think it says, or any sexual activity for which a person can be charged with a criminal offense, right? Which has
been read throughout. Correct. I appreciate you pulling that up.
Yeah.
And it's been read to basically fixate, because you're looking at 2422, and if you look at 2423, it
that's
specifically addresses. Look at which one, 23 or 22.
23.
Do you want to share it? I can pull it up.
2422 and 2423 are the two statutes that she's charged with.
I'll just put it out. I'll send it to the private chat real quick. That's 23.
Okay. So when we pull up these statutes, you'll see that there are references to crossing state lines for prostitution. And the question I had was this. This was what was really, really bothering me. What I assumed the state was figuring was, so we're looking first at 23. So this is, you see, a person who knowingly transports an individual who has not attained the age of 18 years in interstate or foreign commerce, which is both Annie and Kate qualify as being under 18, with intent the individual engage in prostitution, shall be fined and imprisoned for not less than 10 years. So based on this, I don't care if the age of consent. Why do I care whether they were over the age of consent in New Mexico or in New York? They're under the age of 18. And arguably, a jury could find that what they were engaging was prostitution. I mean, they're all engaging in these sexual encounters every time they're having money stuffed in their hands, certainly with Kate. And And even if the age of consent was whatever, she's engaging in prostitution.
Yes.
And that seems to be exactly what 2423A is describing. So why is it that the jury was instructed you cannot convict based on how they treated Kate? I thought that was a really important question to answer. And it's not something that I think is a matter of public record. It's only because I think this was addressed in a sidebar. And what happened, that's what I'm assuming must have happened, because I haven't seen any documentation on it in papers. And what I think happened is this.
Wait, though, Joe, because hold on. Let me see if I'm understanding this, though, because it might be they screwed up with the charge, right? So if the prosecution charged them with A, which A only, well, I guess now you're right, because they're still under the age of 18, regardless, right? So I'm trying to think of that. Maybe they should have charged them with B, because B, like, I mean, that doesn't have an age limit, right? Oh, no, it does.
Well, it's still transportation of minors.
Yeah, it's under the statute.
Okay. So that's why I felt like the minors doesn't mean age of consent. In theory, minors doesn't mean age of consent will vary from one state to another. It's the transportation of someone under 18. So that's transportation of minors. But this is what it seems must have happened here. So you have to understand that there was an argument by the defense saying statute of limitations, this thing is gone. And what the judge basically said was, well, the statute of limitations, and they said and they also argued ex post facto, meaning you pass a law in 2001, 2003, and now you want to try and convict Ghislaine Maxwell for activity that happened in 1994 when the statute of limitations was much shorter. So that's not fair. This longer statute of limitations should not apply here. Right. And what the judge adeptly said was, well, at the time that the statute was passed, she still could have, it was within her statute of limitations. Accordingly, she still was potentially chargeable at that date, and therefore the statute of limitations extension applies to her as well. The court agreed that it would be ex post facto if she had committed these crimes in 1980 and the 10-year statute of limitation had passed. But because we're talking about activity that happened between 1994 and 2001, she was still within the statute of limitations, and accordingly, it could apply. It would apply to her. And I think what happened was this. I think the judge heard an argument at sidebar. This is what I assume must have happened, and I don't think anyone else has realized this. Like when I say anyone else, I mean literally any other human, because I don't think any lawyers are really looking at this case and on the law. And I think obviously the defense counsel and the prosecution and the judge are looking at this, but who else? There are no lawyers who are really inside the courtroom and watching what's happening. The only thing that makes sense to me is that the judge must have parsed this statute out and basically look, because she focused a lot on the language as far as why it is that we give this extended time for children. And I think what the judge did was she parsed this out and she said, to the extent it applies to illicit contact with a minor, that will have an unlimited lifespan for Ghislaine Maxwell. But to the extent it applies just to prostitution, it will not. This is because that's not dealing with a minor, and because we're not dealing with the whole point about the PROTECT Act is protecting minors. So the PROTECT Act doesn't specifically say this statute. It says basically laws designed to prosecute for improper conduct with minors. So she basically parsed this one statute out and said, anytime we find conduct that's showing abuse of a minor as defined by the state, that this person is considered sexually minor, that will have a statute of limitations which goes throughout the life of the victim. But to the extent that the statute applies to prostitution, well, in that case, I am not going to have that. And I think that the reason that Kate's conduct is not up for consideration is because the judge is basically saying that this is beyond the statute of limitations with respect to Kate, and that the extension under the PROTECT Act only applies to conduct with a minor, and since Kate is not a sexual minor in the state of New York when she's 17, ergo this statute should not apply to her. If the judge did this, okay, I could at least I understand how we are at where we're at. I would just point out it's very unusual. it's really unusual because you're taking one statute and you're basically giving two different statute limitations on it. You're saying that you're touching a minor, that's going to be for the life of the person, the life of the victim. And if it's not, if it's just prostitution, well, in that case, we're just going to look at it as a 10-year statute of limitations, which is like the more standard number. And there's nowhere implied in this statute that it should be broken, that there's a difference between prostitution or sexual activity, for which any person can be charged. So it's a little unusual if that is what the judge did, and I cannot figure out any other alternative as to what she could have been thinking. That's how she must be reading this, and it's a little bit of an unusual read to parse it out that way, rather than just saying, look, this statute, transportation of minors, in this setting, the Protect Act is applying because you're a minor, and the broad line rule is 18, as explicitly written in this statute, and therefore everyone's a minor, even if you're above the age of majority in New York or in New Mexico. Mm-hmm. So it's a really interesting thing, which probably will not come up with almost anyone else. I mean, you need to have the right set of factors of someone who's the right age of 17 here and not 18, you know what I'm saying, under 18, and yet over the age of majority during a certain window of time. It's unlikely that this decision will actually have any impact on anyone else ever, in theory. But I mean, I guess going forward, if there are two different statute of limitations periods, in that case, it could foreseeably have ramifications in other cases. And it's not just looking back to predating the Protect Act, but going forward, looking at 18 U.S.C. 2423, does this have two different statute limitations? Does it not? I think that's an interesting question. And according to Judge Nathan, it seems like it does, because that's why she would make a difference between Kate and Annie Farmer versus Caroline and Jane. And I'll just point out, because what she really should have done, to my mind, in looking at this statute, if I was the judge, I would have said, look, you cannot consider them a minor. You can't convict them for illegally touching a minor, but you are permitted to consider whether or not this was crossing whether this was prostitution, and whether Kate was now being prostituted after crossing state lines, and whether that would be a basis to convict under 18 U.S.C. 2423, purely just what happened to Kate. Forget about Jane, Carolyn, whatever. They took her as a 17-year-old from England to New York, and because of that, if the purpose was to bring her across for prostitution, and you find, if you the jury find that she was brought across state law, brought into the country for the purposes of prostitution, that is a sufficient basis to convict and give Ghislaine Maxwell a sentence of no less than 10 years.
And just to clarify, I mean, this case is being charged under this particular statute, right? It's not being charged under New York law or New Mexico law.
It's in federal court, Southern District of New York, and they need to have these crossing state lines rather than just you raped a girl or you sexually abused her,
right? Because that'll be local.
That's how you get into federal court. So yes, it is a. It's this statute and 2422 are the two that she's charged with.
No, and Joe, and that's a very interesting analysis. The first time I've ever heard a lot of that. But I mean, some of that is speculation as to her reasoning, right? Because we don't have written written orders.
Yes.
Like, we don't have the logic. And this is part of the federal process. It's so obtuse, it's so like impenetrable, the federal process. It's not open, it's not transparent, right? I mean, you're having to go through leaps and bounds just to even get in there. Yes. And then you're not able to see a lot of this logic. And I'm sure there's lots of sidebars that you're not seeing in
correct
here.
Whenever they go to sidebar, it's not even on camera. I'm sorry, it's not on camera or anything. We don't hear, there's no audio, there's no video. They'll just be like, Judge, can we talk at the sidebar? And she'll be like, sure, let's go. And it happens frequently,
and then they never come back and put it on the record.
No,
like what they're doing in the Potter trial,
right? Nothing is put on. Not as nothing put on the record. It's basically left to me as one of the only two attorneys in the room to figure out what the hell just ruling was reached, because I'm like, sometimes there'll be objection on a question, and then based on how the questions proceed when they come back from sidebar, I'm sitting there trying to figure out what the ruling was, how did they come to it? And I know I'm sitting with a room full of reporters. These are people who literally turn to me and are asking me, what does objection foundation mean? So I know that, they know what hearsay means, but they're like, what is objection foundation? And I've walked them through basic, rules of evidence. And and I'm not faulting them on that, but I'm saying is that's all the people who are watching the trial. It's me and another lawyer and a whole bunch of journalists who know nothing about the law. So when something weird like that happens, I feel like I'm basically the only human on the planet who could try to figure out what it is that happened and then share it with the world. Well, it's a very onerous responsibility. It's a big weight on my shoulders.
I wonder if this issue on the differences with the statute of limitations and and with the ages of these individuals, I'm wondering if there would have to be some kind of case law that comes in to sort of explain this weird discrepancy, right?
You're saying on the age between the different statute of limitations for prostitution versus touching minors?
Yeah.
I think she was parsing out the underpinnings of the PROTECT law. And that's what the PROTECT law, I think, is like 3854, 3584, something like that, which passed in 2001. Let me see if I can pull that up. The PROTECT Act. It's all caps PROTECT. Like, I think it must be an acronym for something, because politicians love coming up with these cutesy acronyms to show how they're caring about Americans. So PROTECT. Am I wrong?
You mean our 100% infrastructure bill?
Yes.
That's only for
infrastructure. Only infrastructure.
Nothing else has been added in for.
No, I was right.
The resources.
The PROTECT Act of 2003 is a backronym. I don't know how. I never heard a backronym before.
Backwards.
For prosecutorial remedies and other tools to end the exploitation of children today.
Today. It's over.
Today.
It's over.
You know what? You know why? Because PROTECT Act doesn't sound nearly as good. So, and other tools, they worked so hard to come up with this backronym. So, right. So that's basically, if it is, what's the statute here? Let me see. Do they have a number? I don't see it here. PROTECT Act. Let me find somewhere else.
So maybe when you're looking for that, Sulo asks if anyone can point him to a live stream during which Andrew Branco referred to ASMR judge's mommy. Kind regards from a law student in Poland.
It was on Nick Rekieta's stream today.
Yeah.
Oh, it was today? So this morning
it was today's stream. He literally off rip called her mommy because her hair was in an updo.
Oh no.
Yeah, and the chat was simping so hard it was crazy.
So that would have had to have been in the first hour or two of
it was like the first 30
stream.
minutes. It was like the first 30 minutes.
Well, that's easier to find then. So there you go, Sulo. Go ahead and find it and clip it and spread that around. Oh boy.
Just play
I really need new friends.
Play that to Good Girls Go Bad. And then you got like Viva with the hentai, Andrew Branco with that, Alita today. We're gonna get everybody. Everybody's gonna get got.
Oh man. So yeah. All right. Well, cool. Joe, did you find what you were looking for?
No.
Oh,
so
okay.
I have to find out.
All right. Well,
sorry.
So the Ghislaine Maxwell trial starts tomorrow again.
Yeah, we
right?
resume tomorrow. The defense is supposed to open. So the other interesting thing that came out is defense said that they have 35 witnesses to bring forward, which is way more than what the prosecution brought. Yeah. So they're basically going to keep me working on this case, like, I don't know, through like Valentine's Day.
That means you will be overtaking my subscribers. That pisses me off.
Oh yeah. I'll tell you this much. I'm going to Viva Friday tonight, so I'm looking to take you down tonight, sister.
Oh man,
rude.
You got the Canadian.
Guys, don't subscribe. Don't subscribe to Joe Neerman.
I actually started a campaign because I just formed memberships. You actually helped me create the whole membership things.
I know. I helped you. Why did I do that?
So and with that, I told my subs, don't become a member. I think it's the stupidest thing in the world.
I saw that. I was like,
it was great
Joe,
reverse
what are you
psychology.
doing, man?
Great reverse psychology. Everyone was like, well, now I'm going to be an extra member just because of that.
I really mean it though. And I was like, I'm threatening them. That like, look, I'm going to basically be creating holes in the ozone if you guys do it, because I'm going to be buying the worst carbon emitting a vehicle I can find as a way of like punishing them for Say, you want to burn your money? I'm going to burn a hole in the ozone for it. So, right. Well, anyway. So there you go.
All righty. So I think that about does it for me, unless you guys have anything else that you wanted to add.
No.
All
Check
right.
me out Viva
Well,
Fry tonight, though.
Yeah. Go subscribe to Legal Mindset and Not Good Logic.
I need your subs.
Yeah, we can all point in his direction. That's fine.
Yeah.
He's so competitive. Everyone looks at her, it's like, oh, she's this cute little blonde attorney. She goes jogging.
She's evil. Don't trust
every time
her.
She gets 12 more drugs. Every
She's
time
in
she gets 12 more
California.
subs, she's like looking out, and she's like sitting there saying, like, I can't believe that oh my gosh, Joe's catching up to me. It's like, please. I used to be like 1,000 behind you. When you were at 5,000, I was at 4,000. And then all of a sudden, you leaped way ahead of me.
Yep.
You're way ahead of me. You got the blonde hair extensions. You're leaping way ahead of me with Nick's crowd.
I'm getting interviews on my channel. You know,
you're like, also Wisco's coming on. It's like, Kyle's like, oh yeah, I'm gonna go with.
She's gonna be too big for us, Joe. It's gonna be me and you, the old men shouting at clouds.
We're gonna punish you being cis white male. Yeah, we're like,
I'm gonna identify as Lithuanian.
So you surge way ahead of us, and now it's like I'm finally making a little ground by like literally not like working 24/7, and you're like, no, keep him down.
I know, I'm kidding.
So nice.
I like to retweet all of your stuff. I like to support all of your stuff. You are legitimately hustling very, very hard.
Thank
you.
You.
And I like to see it, like even if what if you surpass my subscribers, I'll catch up to you at some point again.
Look
at
this competition. Like
it's so
all
awkward.
I would say is
I'm just gonna let you guys fight it out. I feel like the third wheel here.
I tell people, go sub Legalbytes. She's like, she's gonna make you feel good about your life and about the law. I'm always like saying, go, sub to her.
Yeah,
she's like, stay away from that evil guy.
No,
he's gonna ruin your children.
Not at all. No, but I mean, you legitimately, are hustling very, very hard, and I'm very thrilled to see the growth that your channel has been seeing. It's great. It's wonderful. And I encourage everyone to go and support what you're doing, because you are doing God's work by going in there every single day as a lawyer and analyzing and observing trial and being able to put your lawyer brain to what it is that you're seeing, which not everybody can do, either because of distance or because of training.
Me and Inner City Press, as far as I know, are the only two New York lawyers watching this.
I didn't even know he was a lawyer. He's a lawyer?
I didn't know that either until he was on Viva. Also, I was like, oh, he's ruining my gig. But he is apparently a lawyer, so I can't make that clear. I might be the only New York litigator. I'm not sure. I don't know if he's a litigator. He's a lawyer. I don't know if he's a litigator.
Oh, there you go.
I gotta find my niche.
We side with you, Joe.
Thank you.
Yeah. So one last super chat. Tammy Turner wants to know, can you convict on trafficking without naming who they were trafficked to or who was being trafficked?
They just have to be trafficked. You don't have to say who the John was. Like that's I think that's what they're asking. Like you don't have to name the John.
And you don't have to name the Jane either. You can call her Jane Doe.
I mean, if you're asking whether they need to be publicly named at trial, no, they can be exactly Jane Doe, John Doe. However, I think you still have to identify an individual, because I mean, how else? That's a basic right for any defendant to confront any witnesses against them.
Right. So the way they're working in this trial is the jury is seeing a lot of information that none of us in the viewing room are seeing. So they'll have things under seal, and they'll allow the jury to see it, but when it becomes a matter of public record will be very highly redacted. Or when it came to Jane testifying, where she was testifying under pseudonym, so she had to submit her birth certificate and driver's license, to sort of identify herself, and those records are made available to the jury, but not to the public at large, because most records are public records. So it's under seal that no one can get it there, but the jury who's looking at it understands that Jane's real name is whatever, Julie Connor Smythe or whatever. So
Yeah, and this is common for any kind of litigation that involves private information. So when it comes to the discovery process, where you're getting evidence from the opposing side, it's very, very open, very, very invasive. But if the information that is being requested of you is very personal, like tax records, for example, medical records, for example, you will, depending on if those are related to one of the central issues of the case, or not even necessarily central issue, but one of the issues in the case, you very likely will have to hand that over to the other side. However, you can request a protective order to make sure that none of that information goes public. So it gets handed over to the other attorneys and to the other party, but they are not able to share that with anyone else. So it's similar in a case like this. The identity of these individuals are sealed in that same respect, that the opposing side is able to have access to that information so that they can put on their defense. They can put on their case in defending against those claims. But at the same time, it protects that individual's private information so that it doesn't get widely disseminated.
Correct.
So, yeah,
well said.
If that makes any sense.
Well said.
Makes very
that's why
makes
you have
tons
more
of
subs than
sense.
me. You're able to bring things down in a concise way. So
Thank you.
Good then.
Not always, sometimes. So anyhow, with that, be sure to subscribe to everybody that showed up on today's live stream. Good Logic, even including Good Logic. Legal Mindset. Nate was here. So was Kurt. So I think Nate might be the only one that isn't linked in the description below, but I will go and do that as soon as we.
He has like more than all of us put together. So.
Chop.
No,
But they're all good people, and everybody does something a little bit different, which I really enjoy. Because I mean, it's hard to follow everything, and I kind of feel like every day I wake up and I'm like, what am I covering today? And I'm like, okay, let me see what's been covered, what's being hammered to death, what's another angle I can take, and it's really fun. It's fun doing that.
Yeah, absolutely. So anyhow, that should about do it for me. Be sure to like, subscribe, share all the good YouTubey stuff. If you are interested in supporting the channel, you can buy merch, you can become a member, you can join on Locals and Patreon. All of that is in the description below as well. And then find us all on social media. Twitter is a really great place for that too. That and Locals. Anyhow, I think
Godspeed.
All right.
See ya.
That about does it.